You're watching The Legal Breakdown. So, Glenn, we have reporting from Trump's lawyer, Joe Tacopina, that Trump would surrender without protest if he's indicted on criminal charges in the Manhattan DA's case. What advantage does Trump get by virtue of turning himself in?
He will get no legal advantage. And frankly, I'm surprised that he is willing to sort of go quietly rather than posting something like, "Come to New York for my arraignment will be wild."
Right.
I think that's a good sign. I really think the only advantage is that we probably will not see a perp walk. We won't see law enforcement authorities picking him up somewhere, handcuffing him, and taking him to the police station to be booked. So there is no legal advantage. I think everything Trump does moving forward is now going to be for PR advantage.
Does Trump get released on bail immediately upon turning himself in?
Probably. I find it very unlikely that the prosecutors will even seek any form of detention or pretrial restriction. I think the biggest question is, does the Manhattan District Attorney's Office, do the prosecutors argue that he may present a flight risk? If so, then they could ask the judge to either restrict, for example, his overseas travel. They could ask the judge to have him surrender his passport. They could ratchet things up from there, but I don't expect they will. Of course, they could ask for electronic monitoring, home confinement. I don't think any of those things will be in play. So the most likely scenario is the judge sets bail, he walks out, and he may have some minimal travel restrictions.
Okay. Now, how long after being released would the next phase of this begin? Because in theory, if he wasn't released, he would, be in some type of a holding cell while certain things are happening, certain pretrial motions are happening. So I guess what's the next phase of all of this?
So the next phase is there will be a series of court hearings set by the judge. It's unusual for a judge to set a trial date at the very first court appearance, which is called the arraignment. The judge will probably set a series of interim court hearings or interim status hearings where they can hash out things like what motions might the defense team want to file. And then once there is a motion schedule set, there will be motions hearings that are set on, and that's when witnesses will actually be called on the motions that are filed by the defense to, for example, suppress evidence. So I expect we're going to see a series of interim status hearings and then ultimately a trial date set out perhaps 6 months to a year from the time Trump is presented in court.
So if somebody wasn't released on bail, for example, they would be, I guess, locked up for the 6 months to a year that it would take from, this arraignment to the actual trial itself?
So each jurisdiction has its own rules with respect to how quickly you have to try somebody once they are detained pending trial. So, for example, in Washington, D.C., if you detain somebody pending trial in what I'll call a run-of-the-mill violent crime case, which is where we most often see detention ordered by a judge, we actually have to go to trial within 100 days. If it's a murder case, we have longer. But, a case like this, first of all, I think pretrial detention is extraordinarily unlikely. But once we do detain somebody pending trial, then there are some expedited deadlines that are set by the judge. And let me just tell you, there are only two reasons a judge can order somebody jailed pending trial. If the prosecution can prove by clear and convincing evidence, it's a fairly high standard, that the defendant is either a flight risk or that the defendant poses a danger to the community. Those are the only two reasons that a judge can order somebody jailed pending trial. And I don't think we're going to even see those kind of arguments made by the prosecutors in this case.
Got it. Okay. This one's for my own edification here. Do indictments ever drop on a weekend? Because I need to know, whether I'll be able to leave the house this weekend or if I have to sleep in my suit in the event that Donald Trump gets indicted.
I will say that judges, there is an emergency judge on call 24/7, 365 to handle all sorts of emergency matters. I have never seen an indictment dropped on the weekend, so I think that would be extremely unlikely.
And that's in your long Rolodex of all the times that former presidents were ever facing indictment? You've never seen one happen on the weekend?
A dime a dozen. I've never seen it happen.
Yeah. Okay, so in a separate case here, the DOJ's case into the stolen documents at Mar-a-Lago, a federal judge has ordered Trump's attorney, Evan Corcoran, to provide additional testimony as part of an investigation into Trump's handling of those stolen classified documents. This is being called a monumental ruling. Why?
Because, first of all, rarely do we try to get the lawyer who's representing a defendant, the lawyer who's representing the target of the grand jury's investigation, to appear and testify about what his client said or did, because there is an attorney-client privilege that is very hard for the prosecutors to break through, to pierce. So we usually don't even try it. Really, the one limited exception to that is when we suspect that the client has been committing crimes with the lawyer, or the client has put the lawyer up to committing crimes, whether knowingly or unknowingly, whether wittingly or unwittingly. So I don't think people should jump to the conclusion that Evan Corcoran, Donald Trump's lawyer who's been ordered to testify before the grand jury, necessarily was involved in criminal conduct, because there are two ways that we can use the crime fraud exception to break through the attorney-client privilege. One is if the lawyer is doing something that the client has put him up to, but he doesn't know he's facilitating a crime. And the second instance is when the lawyer is doing something the client put him up to, and the lawyer knows full well he's committing a crime. He is complicit in the crime. And the reason I break that out into those two separate categories is because depending on which category Evan Corcoran falls into, that will dictate what happens next when he goes back into the grand jury.
On that exact note, we have news as well that District Judge Beryl Howell said in an order under seal that the Justice Department prosecutors have met the threshold for the crime fraud exception for Corcoran, meaning that he won't be able to rely on attorney-client privilege here. So with that said, what can prosecutors expect now to get from Corcoran?
A great question. So here's what happens. Now that Chief Judge Beryl Howell has ordered Corcoran to go back in the grand jury and testify, there will be one of two things that we'll see happen. Either Corcoran will invoke his Fifth Amendment right against self-incrimination because he tried the attorney-client privilege, that didn't work, and now if he believes he was complicit in a crime with Donald Trump, he'll plead the Fifth, and he'll have every right to plead the Fifth. If he does, the prosecutors will have a decision to make. Do they grant Evan Corcoran immunity because they're more interested in getting his information about the crimes of Donald Trump, or do they prosecute him? And if they have enough evidence to prove that, sure enough, he was involved in criminal activity together with Donald Trump, they could prosecute him rather than immunize him. But here's the other way it could go. If Evan Corcoran believes, you know what, I did all sorts of things at the direction of Donald Trump, but Donald Trump lied to me. I didn't know the things I was doing were criminal. So Evan Corcoran, under those circumstances, could go in and could testify without invoking a Fifth Amendment right against self-incrimination if he believed he did nothing wrong. That virtually turns him into a trial witness against Donald Trump. So at the end of the day, one way or another, I think Evan Corcoran is going to have to withdraw from his representation of Donald Trump because now he has a conflict. He can't look out for the best interests of his client and look out for his own best interests at the same time.
And obviously, we won't know any of this, so we just have to look for indications like the fact that Evan Corcoran would then withdraw would show us that there's some movement on exactly that point, correct?
Correct.
Okay. Now, ironically enough, we just had spoken about Judge Beryl Howell. This will be one of the last decisions that was handed down by Judge Howell because she's being rotated out of her role. You actually attended the swearing in of the judge who will replace her. So can you quell some concerns here? Is she being replaced by some Trump lackey who all of a sudden is going to defer to Trump in all of these in these cases?
Yeah, I just returned from the gavel passing ceremony where Chief Judge Beryl Howell, who just finished her 7-year term, passed the gavel, actually literally and figuratively, to a friend of mine named James Boasberg. So I say he's a friend of mine. We've known each other for decades. We worked together at the U.S. Attorney's Office in the District of Columbia, and I actually supervised Judge Boasberg when he was a homicide prosecutor. Then I tried a case with him that was really a horrific double homicide of two senior citizens who were a brother and sister who were killed in their own home. So I know James Boasberg extremely well. And what I can say is he is the right man for this moment. Just as Chief Judge Beryl Howell was a terrific chief judge, she was serious, she was fair, she was no nonsense. She made some very difficult rulings. And as best I can tell, all of the rulings that we've seen her make, we don't see them all because they're secret grand jury proceedings, many of them, but all of the decisions we've seen her make seem to be made with a view toward justice and holding people accountable for their crimes rather than letting people get away with either weaponizing the courts or just sort of nefariously using the courts for their own purposes. So she had a terrific run as chief judge in federal district court in D.C. And rest assured, Judge Boasberg, Chief Judge Boasberg, will be just as good, just as strong, just as honest and ethical and honorable as was Chief Judge Beryl Howell. I believe this to my core, having known Judge Boasberg for a very long time. I think, we the people remain in good hands with Chief Judge Boasberg at the helm, overseeing all grand jury matters now during these really troubled times.
Excellent. Well, that's exactly the reassurance that we need. We'll continue to stay on top of this stuff as we wait for indictments to drop in either, the Fulton County case, the Manhattan DA's case, and a number of others. So if you're watching right now and you want to keep up on legal news as soon as it drops, make sure to subscribe to both of our channels. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.